Welcome back
Hello.
to the TO Kids podcast. Today we have a special guest because we needed to fill the roster because people couldn't make it. Welcome Ryan
Yes.
Rodriguez to the podcast.
Thank you. Thank you. I'm glad to be here. I'd like to thank my mother and my father for letting me get this far.
Yeah, but we also brought Ryan on because he today we're going to talk about some aspects of law, and he has probably a better grasp on that stuff than we do because if I'm correct, that's the field you want to go into, that and politics.
Sure. Yeah.
Sure.
Yeah.
Fair enough. So today we are going to be discussing the legal concepts of proving something beyond the shadow of a doubt and proving something beyond a reasonable doubt, and specifically why the burden of proof, why the burden of gathering knowledge is different between a criminal and a civil case.
So in a
Who
criminal,
would like to start?
Sorry. So in a criminal case, it's the beyond the shadow of a doubt, right? Or
Yes.
is it-
Yes, and that says that they have to prove 99% certainty that the person who committed the crime did it, or if they didn't commit the crime. Wait, no, it's only they have to prove that they committed it, right?
Yeah.
Thank you. In a civil case, they operate on beyond a reasonable doubt, where for 51% of the time, a reasonable person would not be doubting like the case, essentially.
Yes.
Now, and again, the question revolves around why is that level of knowledge different when both types of trials have like very weighty outcomes.
Okay. So
I-
two things.
Oh, you want to start? Okay.
Oh, Yeah,
Ryan, then
sure.
you.
I'll go.
You can go.
When we're talking about criminal cases, that usually means that there's a punishment involved, a hefty punishment, usually jail time or fining. So we need to prove for sure, without any like little we'll have that like 1% of doubt maybe, but we want to know for sure that this guy is guilty. Because if he's not, then him getting punished for that crime is awful. Now in civil cases, you have two parties going against each other. It's less of is this man guilty and or more of it is, hey, this guy took my stuff. I think I deserve 2,000. What do you think he deserves? And that's all it is.
But still, there are civil cases that get into the millions of dollars, even to the point where the person that is found liable for whatever.
Sure,
they're
but there's no
being
capital
accused of by
punishment
the other
that can be
party.
involved.
Yeah, but you get what I'm saying. That level of punish. You can see it as a punishment in that way too, being charged with that amount of money to have to be paid. So in that case,
Yeah.
why is the burden of proof for, say, someone who's having to pay $2 million and they only make $50,000 a year, and someone who's getting like a year in jail different? Now, I want to go to Aaliyah because she said something earlier.
Oh, go for it. Yeah, you haven't go.
I was gonna say that the reason why that's a little bit more like a hefty and a bigger deal is because if someone's being convicted of a murder or a murder charge, something that serious, and like let's say they only went into prison for 1 year and they got out, but yet it was still wrongfully accused, they're going to be affected not just for being in the prison for 1 year, but also for the rest of their lives. Like, you got to keep in mind that this person also are going to have a difficult time finding jobs, difficult time being like a chaperone for their kid if they have kids, and just their life is good. So I feel like, as a thinker, I feel like if you want to charge someone on such a serious case, it has to be some really good evidence because it's a really serious matter that can affect them even after they get out of jail. And also taking to the fact of the mental toll that they go through while being in jail and this entire time they're being wrongfully convicted. They could be going through something where it's like, when you know you're right and you know deep down you're right and you're innocent, but if so many people are telling you that no, you're guilty, they're going to probably start believing that they're guilty. And you can also take into the account of the number of cases out there that the defendant has been sort of, I wouldn't say tricked, but like swayed into thinking that they were guilty even though they weren't, through like tactics of in- interrogation tactics.
So, Aaliyah, you mentioned on how like the kind of case the kind of case determines the kind of evidence you have to present. And do you also agree that it also like determines the amount of evidence you have to get? It raises the question on how we measure a good justification or grounds for a claim. Like, how do we know that there's a good justification or grounds to um, a criminal case versus like a civil case?
Well, I think for a criminal case, like my scientific grounds is like the DNA. And, DNA doesn't lie, but like with witnesses, you're gonna have to believe them through their like trial and their testimony and everything that falls under the sun of that. So it's kind of like the jury has to differentiate their teleological beliefs and their scientific beliefs as well. Should they believe in the DNA, the cold hard science, even though your DNA can be transferred by like, if you like shook the killer's hand right here, and then the killer goes off and then kills this other person, your DNA could be passed on to that crime scene. So with that keeping in mind, there can also be some kind of gray areas as well. And with your beliefs being your grounds, there can be some gray areas as well, because what happens if that person is a really good liar? So it depends on the situation and like your differentiation of what is good evidence and what isn't, based on just the case itself. But with civil cases, I think that it's more of um, a teleological belief, because there really isn't science behind it for like a normal civil case.
Now, while Aaliyah was talking, Ryan, it looked like you were bothered by something she said. Do you want to elaborate on
Yeah.
that?
No, she addressed it.
Okay.
It was about the DNA thing. I was like, it's not. But yeah, she addressed it because you can have instances in which you were just at the wrong place at the wrong time at some point, because that your DNA is on the scene and they can use that against you.
Mhm.
And also, another reason why I think civil cases are you need less evidence to prove a civil case, is because criminal cases can involve the taking away of your rights in the form of jail time and in the form of the loss of your ability to vote. So it's much more important to prove for sure that you were the perpetrator of the crime.
Yeah. But let's take for example, let's say we have someone who committed like a small misdemeanor, no jail time behind it or anything, that they're going to get like a small fine, like a traffic fine or something like that. Or not traffic, because that doesn't fall in the same place, but like shoplifting or something, that they're not going to face jail time, but they'll face a fine almost certainly. And you have a civil case where someone is being charges are being brought upon the person for about the same amount by another party. In that case, why do we see one of those as necessitating this 99 percentile, while the other one only necessitates this 51 percentile? Why is the knowledge different when the outcome is essentially the same, disregarding criminal record?
Okay. Can you okay. Can you say that again?
Okay, my mic's fine, right?
Yeah, you're fine. You didn't cut off.
Yeah. You didn't cut off. I missed that first part.
No,
I missed that first part.
Basically, a criminal and a civil trial where they're being brought up for about the same amount of money, and disregarding like criminal records and stuff that will be formed. Say like the case gets sealed after they pay their fine. Why is the burden of proof different in those cases when the outcome is the same? Why is the knowledge needed different between those two cases?
So
again, while the outcome is the same.
All right. So in the case of burden of proof, I think you're talking about something else. Burden of proof is that the one who's accusing in a civil trial, burden of proof is that the one who's accusing the other of committing, like, I don't know, stealing their dog, or whatever. They're telling that's basically telling that the person who's accusing has to bring proof to show that that's true. While in a criminal trial, that's not how that works. In a criminal trial, person's brought up, they try to find if they are guilty. That is the police that is doing their job. And they bring people to the testimony, and you have a lawyer that's trying to defend them, and you have a prosecutor who's trying to get them arrested. It's less of a in a criminal trial, it's less of a person v person than it is person v state.
Yeah, no, but in criminal trials, the idea of the burden of proof still applies because it's the prosecution holds the burden of proof to prove that the person committed the crime. That's what I'm talking about.
But you can still hold the trial without having any proof. You can still you can have very hearsay, but the trial will still occur. Well, in the other situation, the person's like, well, I don't have any evidence, but I think that this guy did. It's never going to happen. You need to have some sort of proof for a civil trial to even occur. While in criminal, it's the police think that the guy did it. We're going to see if we can prove it. And if it's not, then it's not.
So that's interesting.
The other
you bring up something interesting in this that I want one of you to comment on. You say that with a criminal trial, you don't necessarily need this basis of knowledge to go into the trial itself, whereas in a civil trial, you would need this knowledge in order to even get the trial off the ground, which is what happens. Yeah. But then why does the criminal trial have this higher burden of proof whenever the starting knowledge is next to nothing compared to the civil trial? And I want someone else to comment on this.
Okay.
Oh, I was going to bring in a real life situation. It's a case of Mark Carver, and basically, just a rundown of it. Mark Carver, he had carpal tunnel, and he can't really move his hands. He's not really strong in his hands and his arms, and so he was fishing at a lake, and they also found a woman's body in a car at a lake, and she was strangled. And so the police were saying, "Hey, he was the closest. Him and his friend are the closest people there, so let's pin it on him with little to no evidence." And the only evidence that they had was the DNA transfer that I mentioned earlier, because he shook a cop's hand and the cop did not the right procedures at the crime scene. And so that resulted into him being in jail for not a long period of time, but for some period of time. And so I wanted to bring up this real life situation so we can have some sort of basis on it, and the whole thing of how did that affect him? Why did the police think it was okay, or the prosecution thought it was right to lock someone up and they didn't have enough evidence? And also, this man, he didn't have a high enough IQ, he didn't have a good defendant, so we can also talk about the defense on the other hand as well.
You got something to say, Yvonne?
Just thinking.
Okay.
Just thinking.
Yeah, that's a great. So, police, they're the ones who run the investigation. If a police was, a bit corrupt, they could tamper evidence, and they could do it. And even if the guy was nowhere near, if you have a 51% chance of it being true, easy to pin it on him. But it's kind of hard to do that if you need 99% chance true that this guy did it. And you only have, well, he was at the scene of the crime. We saw him do it, bro, I swear. It doesn't really, you don't really get too much out of it.
Within the car that they found the body in, they didn't see any fingerprints or anything like that, and you would think that if someone was going to murder someone and they didn't have that high enough IQ, obviously there would be fingerprints, probably, because they wouldn't think of having gloves. And also, with him, he's not physically capable of strangling someone. So it's just brings up the argument of how did he get prosecuted and thrown into jail with a little amount of evidence? And we can also take into the account of the prosecution sort of swaying him into being guilty.
Yeah. So I think one of the things that I'm hearing between this like discussion is that in this case the 99% of like doubt that is necessary should have helped this man not be thrown in jail. It didn't, probably due to police corruption and judicial corruption, things like that.
A long time ago, probably.
And a long time ago. But that 99% should have helped him. But I want to bring in a case where the 99% harmed the person involved and let someone go free who, in all reality, should not have gone free. That being, of course, the famous trial of O.J. Simpson. Where,
yes.
Where he wasn't he wasn't charged with the murder of the people that he killed because they couldn't get to the 99% proof, whole glove. They couldn't prove it to the 99%. But at that same time, there was a civil trial that happened against O.J. Simpson for wrongful death from the family of the people who he killed, in which he was found liable to the deaths of those people. So in that case, I think it shows how the 99% can also hinder the judicial process. Because if we prove that he did it in a civil trial, and we prove that he doesn't do it in a criminal trial, it seems like almost a miscarriage of justice.
Okay. Yeah. But I think it's much better to have the occasional person go free than to have people who are wrongly accused get put in jail.
You're operating under the have 10 innocent men go free.
I'd rather have 10 guilty men go free.
Yeah, I got it wrong.
Than to have one innocent man put in jail for no reason.
Yeah, we ain't Soviet Russia here.
Because I'd much rather have actual criminals be punished than random people who are just in the wrong place at the wrong time, minding their own business.
Yes. Now,
if an occasional criminal gets free, odds are he's not going to do something again because he's going to have risk of getting put back in for what we assume would be a second offense.
Go on. I was actually going to ask if you wanted to say something.
Oh yeah, so should it be 99%? Because you say that there's like this, how there's 99% for the criminal case and then only like 51% for the civil case. So should there be a balance? Should like the criminal case percentage for proof be lowered?
No. I absolutely do not think. I think if we're gonna do anything to balance it, if we're gonna do anything, it should be raising the civil burden of proof.
Yeah. If anything, it should be raising civil.
Yeah, I think it should probably be raised, probably not to 90%, because as we touched on very early in this podcast, I was gonna say 75. We touched on earlier.
75 is a really good number.
Yeah, the consequences usually aren't as harsh in a civil trial. Sure, it's money, but like you mentioned, Ryan, there's no loss of rights, there's no possible incarceration.
Yeah.
But I still think
incidents where it is like, and civil goes all the way up until it becomes really bad, and when it is like millions of dollars and stuff like that, it's usually tried as a criminal. If you do extreme money laundering, anything like that, it's crime. You're gonna be tried as a criminal trial.
And to be fair, a lot of the bigger monetary cases never reach courts. They're normally
settled
solved in
outside.
litigation. Yeah.
Yeah. Someone goes outside and they're like, "Yeah, I'll give you 50K if you just leave me alone, bro." I'm like, "Alright."
Does anyone have any final comments on this? This was intended on being a shorter episode because of the lack of people, but does anyone have any final comments on this?
Do crimes, kids.
I
think I'm good.
Do crimes. They have to do the 99%.
Exactly.
Yeah, you got time, bro.
You got that 1%.
Wear gloves, bro. You're good.
Make sure to wear your gloves when you're on the crime scene.
Wear the gloves and then plant gloves that are too small for you. That's what we learned.
Oh, now you know how to do a crime.
Stupid.
How to get away with murder.
Alright, well,
my man
how to money
lander
lander 101.
Alright,
they don't fit me.
Thank you for tuning into the Tio Kids podcast, and thank you, Ryan, for coming on today.
No problem,
we did. Thank you for filling this lack of people that we had today.
Anytime, baby.
Thank you. This has been the Tio Kids podcast. Goodbye.
Bye.
Wait. Okay,
Bye-bye.
so
I
already cut it off.